give them one more minute, just because that's... We're close enough. We'll go ahead and call tonight's August 13th Planning Commission to order and start with an announcement. We previously had a item for a cell tower in Schroeder on the agenda. That has been postponed to September 10th. So if anyone was here for that, that discussion will be on September 10th. And we'll move right into approving tonight's agenda and minutes from last month.
I'll move approval.
You have a motion?
Second.
All in favor?
Aye.
Opposed? Here none. New business. Alana and Aaron Bates, 2025-8 IUP. Tim?
Okay, thank you, Mr. Chair, and we do have Eric Pierce, who's going to be representing the Bateses tonight. This is a request for a 5-year interim use permit for a year-round short-term rental of a 2-wall tent campsites at 1805 East Highway 61, which is zoned single-family residential R1. The property size is 2 acres. The zoning is R1, single-family residential. It is the zoning requirements. This is not specifically listed as a permitted or conditional use in the FAR1, and we'll get into that a little bit more later, how we process. We have that catch-all where we're able to process this as an IUP within our ordinance, but we'll talk about that in just a little bit. And the shoreline classification, this is within the North Shore Management Zone of Lake Superior. The general project description, the applicant is requesting an interim use permit to allow for a short-term rental of 2 wall tents on a property at 1805 East Highway 61. The application explains that each tent will sleep 2 to 4 individuals. The applicants anticipate this to be a seasonal use, but may open it to winter use as well, a year-round. The tents will be placed on wooden platforms, and the primary tent will be approximately 16 by 20 feet, and the second tent would be smaller in size. The application site plan indicates a bathhouse will be built with a toilet and a sink and a shower with an outdoor sink. The zoning considerations, this property is within the FR or the R1 single-family residential zone district. And the principal use of the R1 district is to provide for residential uses at a higher density, generally adjacent to or near developed areas, major roadways, or other sources of services. Multiple residential units, mobile home parks, limited commercial uses are allowed on a conditional use basis in this district. This proposed activity does meet the definition of a campground per the Cook County zoning ordinance. The campground is an open-air recreational area where temporary shelters such as tents, travel trailers are intended to provide short-term occupancy, but short campgrounds are not listed specifically as a permitted or conditional use within this zone district, which is where we get into the catch-all in our Article 10 of the zoning ordinance we adopted several years ago, that anything that's not expressly listed as conditional, permitted, or prohibited use in a particular zone district can, at the county's discretion, be processed as a conditional or interim use permit. And so that's why this is able to be go ahead and processed as such, and you have those standards that are included on the pages there for you. And I'll just go ahead and read that. Go down onto page 3. A conditional use specifically is defined as an activity or use that would not be appropriate if allowed outright in any number, but which, if controlled as to the number, location, and activity, could be consistent with the comprehensive plan and not be injurious to the public health, safety, or general welfare. The review of each proposed use must be determined that it will or will not be compatible with the standard of the article, and if found to be, must attach conditions to ensure the continued compatibility. The interim use is a temporary use of the property until a particular date. So a conditional use permit runs with the property, whereas an interim use has to have a termination date, either a specific date, time, year. Sometimes we do it 1 year, 2 years, 5 years, or they can also terminate with sale of the property or transfer of ownership in with the property. So continuing on, the background. This parcel was created in a recent subdivision and it is undeveloped. There is a path that can be traveled on foot or by ATV, but it is not a driveway, nor is passable by a standard vehicle. This parcel is abutting county land to the north. The site conditions and considerations, well, the septic. The application indicates that a bathhouse will be built with a toilet, shower, and a sink, with an additional outdoor sink available outside. The application does not clarify the water source of the bathhouse. Environmental Health Division in the department offered the following conditions of approval, if it is approved: that an approved septic permit that adequately treats the wastewater produced by the bathhouse prior to issuing any land use permits, and that the property is in compliance with Minnesota septic rules, Chapter 7080, and the Cook County Septic Ordinance. For noise, short-term rental from a tent may generate more noise than it would from a structure. Due to the location near public county land, this may not be problematic. Lighting. The application does not indicate lighting details. This may be considered further by the Planning Commission in your discussions. Safe access. There is not currently passenger vehicle access to the parcel. Access to the tent sites is from a shared driveway off of Highway 61. The application indicates a private driveway will serve to access the tent sites. However, there is not currently that driveway access to the parcel, and parking is off the shared driveway on a neighboring parcel. There is not a physical address sign to direct to the traffic to this parcel. So, public noticing. This notice was legally noticed in the Cook County News Herald on August 1st, 2025. 14 letters of notification were sent to adjacent property owners, as well as the county departments, North Shore Management Board, and the Minnesota DNR hydrologist. No written comments were submitted for this particular request. And of course, in the report, you see the pictures and figures that are documented as well. Staff consideration for facts and findings. A conditional use permit may be granted upon finding of all of the following. Number one, the use conforms to the land use or comprehensive land plan of the county. The Cook County Land Use Guide Plan includes a list of guiding principles in Chapter 7, which includes a commercial goal to provide commercial facilities to meet the needs of the residents and visitors. With policy number 42, specialized commercial activity, for example, resorts, campgrounds, ski hills, marinas, kennels, etc., that depends on and requires specific site conditions can coexist with residential and other land uses through the application of standards regarding screening from adjacent uses, traffic conditions, size and scope of the activity, and other similar concerns. Number two, the use is compatible with the existing neighborhood. The site is accessed through a private easement with other private property owners. This use will be compatible upon the installation of a driveway, parking area, bathhouse, and septic system as described within the application. Number three, the use will not impede the normal and orderly development and improvement of the surrounding area of uses permitted by right and in the zoning district. The small scale of the proposed 2 rental tents should not interfere with the neighboring development for residential uses. Number 4, the location and character of the proposed area is considered to be consistent with a desirable pattern of development in the area. This property is within the R1 zone district. The principal purpose of the R1 zone district is to provide for those residential uses at that higher density, generally adjacent to or near development areas. Multiple residential units, mobile homes, and limited commercials uses are allowed on a conditional use basis in this particular zone district. Additional findings should address the following as an interim use request. Such use will conform to the zoning regulations if the date or the event that will terminate can be used to identify with certainty, so there has to be a definitive date or time or activity used to terminate the interim use permit. Permission of the use will not impose additional cost on the public if it is necessary for the public to take the property in the future, and the user agrees to any conditions that the county deems appropriate for the permission of the use. Staff recommendations for consideration. The application, or the applicant, has requested a 5-year IUP, or interim use permit, for the short-term rental of the 2 wall tents year-round. Staff recommend that the Planning Commission consider the current undeveloped status of the property and speak with the applicants further about their timeline for installing the driveway, parking area, well, and septic systems to support the bathhouse and tent facilities. No written comments were submitted with this request. Staff recommends that the Planning Commission evaluate the request based on the criteria specified within the Cook County zoning ordinance to determine whether the proposed use meets the standards outlined in Section 10. As a conditional use is defined as a special use and is not typically appropriate within the zone district. The applicant must demonstrate that they do meet the criteria for the permit, and interim use permits may be issued for a specified period, such as 1 or 2 years, or 5, or even terminating with the property change, to allow for a trial period to assess the applicant's compliance with the conditions and compatibility with the neighborhood. Initial potential findings have been prepared and may need to be revised following the public hearing and Planning Commission discussions. And finally, if approved, the following conditions could be considered. All local, state, federal regulations must be followed. An appropriate or an approved septic system that adequately treats wastewater produced by the bathhouse prior to the issuing of any land use permits. The property is in compliance with the Minnesota Rules, Chapter 7080, and the Cook County Septic Ordinance. And following approval of the County Board of Commissioners, the interim use permit shall be valid for a specified period of time. The request is for 5 years, but this board could grant a different time period based on the discussion that you do have and any comments that are rendered. And after this period, no rental shall be permitted without a renewal of that interim use permit. All rental tents and structures shall meet the 50-foot rear yard and 10-foot side yard setbacks. A driveway shall be installed with a parking area on the subject property prior to short-term rental activities. No short-term rental activities will be permitted until proper wastewater facilities are established, approved by the Cook County Environmental Health Officer, and physical address sign for the turnoff to 1805 is installed prior to rental activity. That is the report.
Thank you, Tim. At this time, I'd invite the applicant's representative to, if you'd like to add comments, come forward and state your name and address, and add comments if you wish.
My name is Eric Pierce. I'm the representative for Aaron and Alana Bates. They wanted to do their due diligence and make sure they took the correct steps before taking any other major planning. They appreciate their neighbors and respect them and their privacy. This is a pretty simple, just to make clear, it's 2 wall tents. Like, there's 2 small tents. But anyways, that being said, anything that's asked of them moving forward with the county as far as driveways and things like that, or septic systems, will be addressed.
Thank you. At this time, I'd open to the public if anyone from the public wishes to comment on this case. Hearing none, I'll close it to the public and we'll discuss as a board.
Do we have a sense of what the water source is going to be?
For now, it's carrying
Okay.
Carrying
there'll be a small holding tank, actually pulling water from my house, clean public drinking water from my well, in a holding container for that bathhouse, to run the sink. It's basically a gravity fed hand washing station.
Okay.
Excuse me. I was just looking at figure 3. There's kind of a stream course there. Is there a driveway going to be built into a drivable driveway put in to get in?
Yeah, in the future, they plan on building their home to live in Grand Marais on that site where the tents will be. So at some point in the future, actual driveway to cross everything to get up to their living home when they actually build. However, they can establish a parking spot before the creek if that is, a major concern as far as how they're going to cross that. Obviously, they're going to follow any guidelines or stipulations for culverts and things like that and getting the proper permits to make a driveway. But if for the momentary, get this start rolling, they can create a parking spot before that creek access for crossing.
Okay, Mr. Chair, the reason I ask is just looking at that picture, it seems like a wetland delineation probably might not be would be advisable to make sure, because it could be a wetland adjacent to that stream course before you, so you don't have to tear your driveway out after you put it in. I had a follow-up question. So the driveway, and then that driveway is just for this site, it comes off a shared driveway that currently exists?
Yeah, the shared driveway for 1803, 1809, 1807.
Okay, okay, I thought that's what
You see
it
that
said, okay.
Whatever figure it is, diagonal off of it.
All right, thank you.
I have a question about county policy on tents. So we're looking at this specifically because they want to run it as a rental. Just to clarify our treatment of campgrounds and putting up tents on property, that's my understanding, is we're looking at this really because they want to run it as a short-term rental, but it's not covered under the vacation rental ordinance.
Well, yeah, Mr. Chair and Commissioner Stucker, there are a couple elements associated with that, and much like activities within Cook County is kind of rather eclectic in nature in terms of how certain structures are used or yurts are used or whatever the case may be. So you have your element of the fact that it could meet the definition of a campground, and you have those tents that aren't typically used for the rental kind of thing, but we do have that catch-all to be able to include and process it to make it legal if it is deemed by the planning commission, and then subsequently this would go in front of the board of commissioners for their approval as well. But that's why it's being reviewed, because it doesn't necessarily fit specifically into any one of those particular categories, but we do have the catch-all that allows us to process this.
So if the idea was not to have it be a rental, it would just be treated as a building permit,
That is correct.
typically? Okay.
Yeah.
Brett, anything else?
I've got a question about the water supply coming from another property. Is this from a well, or how do you get your water?
Well, yes.
Is it tested?
150 feet deep, yes. We have a rental as well. It is tested every year.
Is this going to fall under the Minnesota Safe Drinking Water regulations as far as crossing a property line from another location? How does that fit?
Oh, okay, yes, again, Mr. Chair and Commissioner Floyd. Again, there are a variety of circumstances in which we do have remote rental sites out there that the Planning Commission has approved that are carry-in water only, and those can come from tap in the city or from the well. We do work very closely with the Minnesota Department of Health for any of the operations that do the requirement for, or do require a vacation rental license, that we have to work with them, because they don't expressly, permit, or they've been working with being able to permit the carry-in water and those kinds of things. So we've got kind of a hybrid relationship that we've worked with them to work those elements out. But yes, it's something that we have approved before.
Because this is not carry-in water.
Well, it would be carried in from another well, but it would be carried in at this point.
I thought,
Carried in is just brought from one source to another source. I think people think of 2-gallon jugs walking in there with. but
right,
Many of the facilities that I've cleaned in or seen have holding tanks essentially where they're bringing in more than 2 gallons of water.
thank you.
Sheila?
I don't think I have any questions. You guys covered them.
Hearing no other discussion, anybody want to make a motion?
I've got a bit of a concern about the length of time on this of 5 years. I realize it's going to take him probably close to a year to get a septic in there, with being so busy with all the contractors up here, and to get the infrastructure in there. And then that would, if we made it more like 3 years, that would give them a couple years of use, and we would have a better idea and just decide in 3 years if we want to renew this. And it would expire upon the sale of the property, would be, I'd be good with that. But 5 years is stretching it. It's a little long for me.
Had a similar concern about the duration.
Yeah, I don't remember any other 5-year IUPs we've had.
And when people have done things, not the same, but for example, the wedding venue, right? We put them in place for a year, and then after a year, there's no problem, so then we extended it. So it was a natural way to, as you point out, see how things are going and then decide if it goes longer.
I think we also had a previous wall tent proposal that was officially withdrawn, but a lot of us probably read the packet and or visited the site. So I think it's useful to have, I think, a little bit shorter period of time to get some feedback. Because I think part of the potential speculation in this assessment is whether noise is an issue with it being a wall tent rather than just a cabin
Correct.
of the exact same size, which we wouldn't even see in this conditional use permit format necessarily. But I think having 3 years gives a good chance for feedback, bring it back up, and see if any of that is actually founded.
I move for approval for a 3-year permit that, with all conditions listed, and expiration upon the sale of the property to another owner.
I'll second.
We got a motion and a second. Any more discussion? I just want to clarify, Tim, would that be then the a seventh condition, the expiration on, am I missing? Expiration on sale of the property?
Mr. Chair, I think we could fold that into number 2, where it would say, following approval of the County Board of Commissioners, the interim use permit shall be valid for 3 years, or the sale of the
Or sale
property,
of property,
whichever
and
comes
fold
first.
that into 2. So we got 6 conditions. Motion approval, I'll call for a vote. All in favor, say aye.
Aye.
Opposed? Hearing none? And with that, we'll look for a motion to adjourn the planning commission.
All motion to adjourn.
Second?
All in favor?
Aye.
Just give people a moment here, and then we'll start the Board of Adjustment. So.
Point of clar- IUPs don't follow the property, they follow the owner, right?
The
do they?
IUPs, we have to specify.
Okay.
CUPs follow the property,
Yeah, okay.
period. IUPs, we have to specify.
Yep.
Yeah.
Just,
We'll go ahead and call our August 13th Board of Adjustment meeting to order. Start with last month's minutes and approving tonight's agenda.
Move to approve the agenda and minutes as written.
I wasn't here, so I'm looking for somebody.
oh, I'll second it. I second it, Mr. Chair.
Motion to the second. All in favor?
Aye.
Opposed, hearing none. Our first item has been postponed, if I'm reading this right, so we'll go to item B. Glenn Helgeson and Rita Helgeson, 2025-11V. Tim?
Thank you, Mr. Chair. This variance request is to place an addition that's 10 feet by 19 feet covered screen porch with a 2-foot eave and a partially covered 6-foot by 10-foot deck at a reduced ordinary high water level shoreline setback of 88 feet from Caribou Lake, which is a recreational development classification, and where a minimum of 100-foot setback is required, located at 112 Peninsula Road. The property size is 2.4 acres with 290 feet of Lake Caribou or Caribou Lake shoreline. The zoning is Lakeshore Residential Zone, and the classification of the lake, again, is recreational development. The cabin that exists there currently meets the 100-foot setback. The proposed addition would be no closer than 88 feet from the shoreline. Background: the county property tax records indicate that the main cabin was built in 1938 and maintained over time to have an effective building date or build date of 1980, being that it then is a existing legal nonconformity for the structure, or existing structure, yeah. The Cook County zoning ordinance does permit decks without requiring a variance to be added to nonconforming setbacks if they meet the criteria outlined in 9.03 of the Cook County zoning ordinance. We did put that addition into the zoning ordinance back in 2003 because we were running into a lot of the pre-existing cabins that very frequently came in for variances for decks much like this, and we just determined that those standards would be acceptable without having to run through a variance process. So those standards are then that it would be constructed prior to August 31st of 2003. The deck shall not have any sidewalls or roof. The deck shall not exceed 8 feet in depth, and the closest point of the deck addition from the nearest high water level mark shall be no closer than 50% of the required setback of the zone district. Due to the age of the cabin, the structure is eligible to have the deck addition meeting these criteria outlined in. However, the proposed project is larger in size and scope with the enclosed porch and with roof, and thus does not meet the performance standards, which is why it is in for the variance today. Site conditions and considerations. The property is served by a septic system. The impervious surface coverage is within the 25% impervious surface coverage allowance. Wetlands are not an issue for the need for the variance. The slope is relatively flat. Slope is not an issue driving the need for a variance. The shoreline health. The property is well vegetated. Trees are present between the structure and the lake to provide visual screening. Mowed paths are present along the shoreline with a wide swath of turf grass immediately along the lake shore in the shore impact area. Public noticing the application was legally noticed in the Cook County News Herald on August 1st of 2025. 13 letters of notification were also sent to adjacent property owners as well as to the county departments and the Minnesota DNR hydrologist. The following written comments were received during the written comment period. John Bell from 130 Peninsula Point Road expresses no opposition to the variance request and feels that the request is tasteful and does not negatively impact the neighbors. And this is an adequate setback to protect the shoreline environment and appearance. The property, or the Caribou Lake Property Owners Association Board of Directors, expressed two of their core values, that their core values are preservation and protection of water quality and shoreline aesthetics of Caribou Lake, feel that the shoreline vegetation is adequate on this site, and that the property currently has adequate visual screening from the lake, and they do not oppose the request, but request that two conditions be considered: that stormwater management of the water runoff from the addition, and two, protective measures from the shoreline vegetation to remain intact. The Cook County Soil and Water Conservation District provided a technical memo that explained the unique improving water quality trend of Caribou Lake, indicating good land use practices by lakeshore owners and the active Lake Association's efforts. The memo indicates that the land use impacts have had a direct impact on phosphorus loading into the lake, which impacts water quality. And the memo indicates that good stormwater management and shoreline and vegetative buffer are good. So the Minnesota DNR Department of Natural Resources hydrologist provided the following: that they find the application is neither controversial nor problematic as far as they are concerned. So the staff considerations for facts and finding going along, the variance is consistent with the goals and policies, again, of the comprehensive land use guide plan, and in harmony with the general purpose and intent of the Cook County zoning ordinance and other Cook County official controls. Number one, the county zoning ordinance number 37, section 7.05 requires a setback of 100 feet from the recreational development lake. The applicant is proposing an 88-foot setback from Caribou Lake. Number two, Cook County Land Use Guide Plan general land use goal is to have an inventory of land suitable and appropriately located for the anticipated types of land uses compatible with natural resources and proximity to existing infrastructure to protect non-compatible lands and land uses from one another. Policy number 13 is redevelopment of already developed lands is generally preferred over the development of undeveloped land. Number three, Cook County Land Use Guide Plan, natural features and environmental concerns goal is to maintain and enhance the quality of natural resources and native ecosystems within the county. Policy number 16 within that is to evaluate and minimize adverse impacts on air quality, surface and groundwaters, wildlife habitat, ecological systems, and other natural features through land use decisions. Number four, Cook County Land Use Guide Plan administrative and intergovernmental goal is to integrate land use concerns into all appropriate ongoing administrative actions. Policy number 77 there indicates land use related decisions shall recognize the need to duly consider the rights and responsibilities of the general public good with the corresponding rights and responsibilities of the individual. The proposed use of the property is allowed in the land use district in which the property is located. The property is zoned lakeshore residential. The parcel is conforming in size with 2.4 acres of lot area and approximately 290 feet of shoreline. Residential uses are permitted in this zone district. The property owner is proposing to use the property in a reasonable manner not permitted by the Cook County zoning ordinance. The property owner has requested a deck and screen porch addition that are beyond the size and the scope of the current deck addition allowance in the Cook County zoning ordinance. The encroachment into that setback will not encroach into the shore impact zone. The property owner has established that the practical difficulty involved is due to circumstances unique to the property and not created by the property owner. The staff encourages the Board of Adjustment to evaluate whether there is a practical difficulty necessitating the need for the variance. Design preference and landowner desires are not necessarily valid practical difficulties. Here are some considerations. The cabin currently meets all setback requirements. The property is eligible to add a deck addition within the late setback area, meeting the design standards outlined in the Cook County zoning ordinance. The applicants have chosen a project that does not meet those particular design standards. The application indicates that the practical difficulty is the location of the original structure and the desire to add exterior space to the structure with a lake view. Approving the variance maintains the essential character of the locality. The area is zoned lakeshore residential. The addition will likely not be highly visible from the lake due to existing tree cover, and it will be in line with the current structure. The property owner has established that the practical difficulty involves more than economic considerations alone, and economic considerations are not the reason for this variance request. So the staff recommendations for consideration, the staff encourages the Board of Adjustment to review the proposed variance request following public comments. Further discussion should address the practical difficulty requirement to approve the variance. Cook County zoning ordinance has a provision that would allow for a deck addition with specified size and design requirement to be added without the variance approval. But if approved, the following conditions may be attached to this variance request: that the property shall conform to Minnesota Rule 7080 and the Cook County septic requirements. All permits shall be in place prior to the initiation of any construction. The layout construction must occur according to the plans approved by the Board of Adjustment at its August 13th meeting. Vegetation shall be maintained and approved to provide adequate visual screening of the addition from the lake. Turf grass shall be limited within the shore impact zone to access paths and recreational areas. Gutters shall be installed to manage stormwater, and the screen porch shall not be enclosed in order to become living space. The rest of it is review criteria that you have, and that is the report.
Thank you, Tim. At this point, I'd like to invite the applicants or their representative to step forward and state your name and address for the record. And add any additional information you'd like to add at this point.
Yeah, I'm Rita Penrod Helgeson, and the address is 112 Peninsula Point Trail. That's the cabin address. We live in Minneapolis.
And I'm Glenn Helgeson, Rita's husband.
Would you like to add anything to? Yeah. go ahead.
Nothing that's already been said. I think it's covered, and we're members of the Caribou Lake Association, so the values are our core values, and we intend with everything we design and do to be true to those values.
I just want to add a couple of reasons for this. Number one, over the years, it seems like the bug issue is, we had a cabin up on Christine Lake, and so we've been owners up here for about 10 years. And we would like to be able to go out and have a screen porch that's accessible, because I've already had 2 knee replacements and we're 65. And this would allow us just to step out from the kitchen and be able to sit out there and be able to enjoy a dinner without getting eaten up by mosquitoes, and also in case it rains. So we
And
care
family
very.
members.
What's that?
Family members who need the access, who are in wheelchairs.
Yeah. So we want to do a single level living as we get older. And as we do have a lower patio, but we have to walk down to that. And to screen that would require pretty much blocking the view from the living room, and it would be impractical.
All right. Thank you. Does anyone else in the public wish to comment? If so, please step forward and state your.
Just say it from here, I think you can hear me fine. We're next door neighbors.
I do name your name and address.
Tom Christensen, 104 Peninsula Point.
Thank you.
Marcia and I are next door neighbors. I believe we should support their variance. The building there, their main cabin, or the large building, is, like you said, 1937 or 39 built log home, which for Caribou Lake is a fairly historic building. The previous owner had a book with vice presidents from the United States who had stayed in that building, and I think they're doing a sympathetic addition to maintain the spirit and the quality of that house. And as speaking for our neighbors and myself, I think it's a good variance to apply for.
Thank you. Anyone else from the public wish to comment? Hearing none, we'll close to the public and discuss it as a board.
Okay, Mr. Chair,
Jeff, go
I did visit the site. It is very well maintained, very nice. I didn't see any issues. I think for me, one of the things is, under the grandfather, you can use 50% of that setback, and they're only asking for 12 feet. So I think seems pretty reasonable to me. I do have a question for staff. Where did condition number 6 come from?
Mr. Chair, and Commissioner Lee, that has been kind of an ad hoc condition that has actually, for decades, that has been kind of thrown on. Sometimes it's used more than others, and the whole point of concern does come from like soil and water and such for erosion purposes. We don't want to have too much runoff going towards the lake, and that's kind of where that is. So where you do have those roofs without any gutters or catchment systems, then you get those lines right off of the roof down at the bottom of the walls that end up going that way. That's just, it's been a standard thing.
Well, Mr. Chair, I'm going to ask that to be removed because it's contrary to what somebody has said is appropriate, because that actually concentrates your stormwater if it's not put to a rainwater garden or to a storm sewer system. So I would like to see that removed. I'm sorry, 35 years of dealing with stormwater, I think I have the benefit of questioning that. Because basically your gutters concentrate your stormwater flow. And so if it's not appropriately treated, it actually makes things worse. So I'll just go on record for that, and I'll probably have to talk to staff about that. But otherwise, I believe this, based on what I saw on site, this seems very appropriate.
So I'm looking at our 2003 non-conforming deck statement here. So the only point of disagreement with what that says and what has been proposed is essentially that it has a roof, correct?
It's roof, and I think it's
2 feet.
Bigger than 8 feet.
8 foot in depth?
Yeah.
Yeah, because it's 10 foot.
Okay. Good. Yeah, I mean, I think to Commissioner Lee's point, I think actually it's an interesting situation we find ourselves in because with an uncovered deck, I think you've got the same kind of stormwater issues just raining right through the deck. So I'm inclined to look favorably on it in that I don't think it's particularly different in spirit from that. So I'm weighing that in my mind.
Both of their thoughts have kind of, I'm in agreement with them in the sense of the roof, the screen. I get those things. I don't know what the thought process was in 2003 with no roof, no screens, kind of an approach to things. And I think Commissioner Stucker's comment about keeping within the spirit kind of hits it.
My question for you guys, how do we feel about our findings of fact? Do we want to concur with staff, or do we want to go through each individual one?
Mr. Chair, I'm comfortable with what the staff has set out for facts and findings based on what I saw on the site and what the proposed plan is.
Okay. The one thing I think we should maybe address is the practical difficulty. And I think I heard the applicant talk about, to me, it seems like the size is the reason to kick it to here, that it's not just approved. And if we've got needing needing space for wheelchairs, or just generally a little bit more of a, however we word that, I think, to me, that does then tip the balance on the practical difficulty discussion. But I just wanted to
So,
address it here,
yeah.
because I think
And I would clarify
need
that
to-
to say accessibility, given the historic
accessibility, yep, that's
nature of the
trying to
cabin.
come up with the right word.
There we go, yes.
So with that was the thing I had a concern with, so. As far as the gutters, I guess I'm inclined to suggest that the applicant, address the stormwater somehow so we don't concentrate, whether that's properly treated at the end of a gutter system, or, I mean, the intent of it, I'm okay with taking it out, but as long as we're understanding as long as the applicant's understanding the concerns is the, erosion control and all that, so. With that, you guys want to craft a motion?
Mr. Chair, I make a motion to approve the variance with all of the conditions provided by staff except for number 6.
Okay,
I'll second.
second. Any more discussion? Call for a vote. All in favor?
Aye.
Opposed? Hearing none? That motion is approved. All right. Item C, Timothy Williamson, sorry if I messed that one up, 2025-12V. Tim?
Okay, thank you, Mr. Chair. This variance request is to place a cabin at a reduced size, or reduced side yard setback of 25 feet in the Resort Commercial Residential, or RCR Zone District, on a substandard lot of record where a minimum of 50 feet is required, located at 40 Godden's Drive.
Godin.
Yeah. The property size is actually 1.41 acres with approximately 211 feet of Lake Superior shoreline. This is actually lot number 11 within the Sugar Beach plat. The zoning is entirely within the RCR zone district, where the lot sizes are basically 5 acres in size and 300 feet in width for the structural, and at the structural setback. The shoreline classification, this is all within the North Shore Management Zone. We'll get here, let me see I don't want to be redundant. So the Cook County zoning ordinance describes the resort commercial residential zone district as the principal purpose being to provide for the specific commercial activity of resorts, lodges, and outfitters. Residential uses and limited service-oriented commercial uses are also allowed. Permitted uses within the zone district includes permitted use number 1, which is single-family residential dwelling, manufactured home, or modular homes. The variance relief request is within the RCR zone district is outlined in section 4.17, whereas the side yard lot size is 50 feet and the rear yard is 50 feet as well. We have here a substandard lot of record. This is, again, one of these pre-existing lots of record. It's a legal non-conforming lot. Non-conforming single lot of record may be allowed as a building site without any variances for the lot size itself, is what it's saying, not any variances whatsoever, but variances. If this weren't a pre-existing legal nonconformity, there would have to be a variance for the fact that it's a substandard size lot of less than 5 acres in that zone district. But because it is an already pre-existing lot, it's a legal existing non-conforming lot, and therefore does not need a variance for that in and of itself. So all structure, it may be allowed without a variance for the size of the lot, provided that all structures and setback distance requirements can be met. Sewage treatment system consistent with the Cook County zoning ordinance can be installed, or the lot is connected to a public sewer. The impervious surface coverage does not exceed 25% of the lot, and the lot is in separate ownership from abutting lands, except for lots created either by court order or through the Cook County Boundary Commission or platted subdivisions approved by the recorder, county and recorders in the office of the recorder register titles after 1971. So the background of this is the lot was created in 1984 as a part of the Sugar Beach plat, and the entire residential plat is zoned RCR and consists of several non-conforming substandard lots that do not meet the lot area or the lot width requirements for the RCR zone district. The Sugar Beach Resort is on the east side of the Sugar Beach plat and consists of several individual parcels. The subject property currently has a residential structure supported by a septic system and well. The applicants have been property owners of this parcel for 38 years. Current applicants are live in living quarters above the garage. The variance request was described as a guest house in the legal notice due to the current living quarters over the garage currently serving as the principal dwelling. However, the variance is for a structure that will be the applicant's primary home or dwelling. Now, I will say, take a little things here. Normally, when there is this plat, and this obviously doesn't happen or didn't happen at that point in time in 1984 and in that area, when we approve zones and we approve plats, if we are going to approve a plat, as we have for, say, the golf course area there, we will approve the plat. If it's smaller than the required lot sizes, we also adjust the setbacks to accommodate for the smaller size lots. This wasn't that case. They approved the small size lots, but they didn't adjust the setbacks to accommodate for the smaller size lots. That's why we're in this room today. Okay, site conditions and considerations. Septic Environmental Health Officer Jesse Johnson provided the following comments, that prior to a new dwelling being occupied and approved, septic permit for a new septic tank, the new septic tank to be installed, and a certificate of compliance for the new construction or new installation, and that the property is in compliance with Minnesota Rule 7080 and the Cook County Septic Ordinance. Impervious surface coverage, the parcel will meet the impervious surface coverage requirements. Wetlands, the wetlands are not an issue driving the need for the variance. The slope, the site is relatively flat and slope is not an issue driving the need for the variance. There is a drainage that is present along the western property line, partially visible in aerial images. The building site meets all bluff setback requirements. The applicants indicate that the part of the reason for the chosen building location is due to the cluster of mature conifer trees in the figure below. These trees are largely located within the 40-foot structure setback. Public noticing. The application was legally noticed in the Cook County News Herald on August 1st of 2025. 10 letters of notification were also sent to adjacent property owners as well as the county departments, Cook County Soil and Water, Minnesota DNR Hydrologist, Tofty Township, and the North Shore Management Board. We did receive written comments were submitted relative to this request. Jay Bosch at 36 Godin, how do you pronounce it? Godin? I should know that. Submitted a written comment with no objections to the request and noted that the approval of this variance would be consistent with the character of the other properties in the area, and the Minnesota Department of Natural Resources did provide no comment to this particular request. Staff considerations for facts and findings. The variance is consistent with the goals and the policies of the Comprehensive Land Use Guide Plan and in harmony with the general purpose and intent of the Cook County zoning ordinance and other Cook County official controls. The Cook County zoning ordinance requires a side yard setback of 50 feet from the resort commercial residential zone district. The applicant is proposing a 25-foot setback from the side yard lot line. The Cook County Land Use Guide Plan general use land goals is to have an inventory of land suitable, appropriately located for anticipated uses, anticipated types of land uses compatible with natural resources in proximity to existing infrastructure and to protect non-compatible land uses from one another. Policy number 13 states that the redevelopment of already developed lands is generally preferred over the development of undeveloped land. Number 3, the Cook County Land Use Guide Plan natural features and environmental concerns goal is to maintain and enhance the quality of the natural resources and native ecosystems within the county. Policy number 16 there says to evaluate and minimize adverse impacts in air quality, surface and groundwaters, wildlife habitat, and ecological systems and other natural features through land use decisions. Number 4, Cook County Land Use Guide Plan residential goal is to provide a range of residential options with respect to cost, density, and development and locations within the county. Policy number 30 there indicates to residential density should be greatest near areas of concentration of commercial and public services and employment opportunities. Cook County Land Use Guide Plan administrative and intergovernmental goal is to integrate land use concerns into all appropriate ongoing administrative actions. Policy number 77 there says to land use related decisions shall recognize the need to duly consider the rights and responsibilities of the general public good with the corresponding rights and responsibilities of the individual. The property use of the property is allowed within the land use district in which the property is located. It is RCR zoning. In this zone, in the parcel is lot 11, consisting of 1.41 acres with about 211 feet of the Lake Superior shoreline. The property owner is proposing to use the property in reasonable manner not permitted by Cook County zoning ordinance. The property owner is requesting to place the residential structure 25 feet from the side yard lot line. The side yard setback distance from a residential use would be conforming in the neighboring single-family residential R1 zone district, which has a 10-foot wide side yard setback for residential developments. And I'll take just a quick break to say there too, the other, we had discussed with the property owners too, the other kind of relief for this would be a simple rezoning of those particular parcels. And there was some discussion about that, but length of time, and it would make more sense if you could get all of those other parcels on board to do a full rezoning of that. But these parcels exist and the plat exists as they are right now, which is why individually we're doing it, and it would be faster for everybody just to do it as a variance. And notwithstanding, a rezone could be something contemplated in the future for this as well. The property owner has established that the practical difficulty involved is due to circumstances unique to the property and not created by the property owner. Staff encourages the Board of Adjustment to evaluate whether there is a practical difficulty present necessitating the need for the variance. Design preference and landowner desire are not valid, necessarily the practical difficulties. Here are some considerations. The 55-foot setback for the RCR zone district is typically applied to the larger yachts, larger lot sizes. Since the RCR zone district has a 5-acre minimum lot area requirement, the board could consider whether the historic plat and RCR zoning constitute a practical difficulty. Conforming building locations are present on the property which do not require a variance relief. The applicants indicate that once the setback requirements are taken into consideration, approximately 0.30 acres of the overall area is available for conforming building site locations. The applicants indicate that the need for the variance is to maintain the trees on the site. The conifer trees presents are largely located within the 40-foot of the vegetation line. Approving the variance maintains the essential character of the locality. The area is zoned resort commercial residential consisting of non-conforming lots. The subject parcel is located at the end of a dead-end road. The abutting property closest to the encroachment is zoned single-family residential or R1, which has a 10-yard side yard setback. 10-foot side yard setback. The property owner has established that the practical difficulty involves more than economic considerations alone. Economic considerations are not the reason for this variance request. And staff recommends recommendations for considerations. The Sugar Beach plat was created in 1984, was likely zoned RCR to reflect the historic resort and protect associated property rights. Today, several lots on the west end are no longer tied to the resort and are used as private residences. While residential uses are permitted in the RCR zone, they remain subject to its more restrictive setbacks. The subject parcel is approximately 185 feet wide at the proposed building site with a 50-foot side yard setback, allows for approximately an 85-foot wide conforming building envelope. The applicants state that they were unaware of the RCR zone standards when they were designing their project and only learned of them upon applying for a land use permit, and they intended to apply for a rezone to a more restrictive and appropriate residential or more appropriate residential development for the single-family residential. Staff discussed the rezoning with the applicants and noted that this lot and nearby non-resort lots could be good candidates for an R1 rezoning due to their size, use, and adjacency to an R1 zone district. However, no rezone application is submitted, and the potential rezone is not a valid basis for just the variance in and of itself. Following the public hearing, the Board of Adjustment should consider whether the practical difficulty does exist and the variance request stems from the landowner preference. If approved, the following conditions may be attached to this variance request: that the property shall conform to Minnesota Rule 7080 and the Cook County septic requirements. Prior to the new building being occupied, an approved septic system or septic permit for the new septic tank be installed, and a certificate of compliance for a new septic installation, and all land use permits be in place prior to the initiation of construction, and layout and construction must occur according to the plans approved by the Board of Adjustment at its August 13th meeting.
Thank you, Tim.
Thank you.
Would the applicants like to add anything to? If so, please step forward and state your name and address for the record.
Yeah, I'm Tim, and I reside at the property of discussion at 40 Deans Drive. Thank you, Mr. Laboda, Chair, and members of the board for considering this. So as Tim mentioned, I only became aware that 10-foot setback was not the norm, because that's really consistent with all the other properties actually throughout this resort. If you look, there's virtually no property that's developed that doesn't have a structure closer than 50 feet from side setbacks. I was living there the last 5 years. I have owned it, like Tim said, 38 years. Lived there full-time the last 5 years. Before that, it was more of a getaway for family. I recently married Lisa here just 5 months ago in Cook County, and we decided that this would be our home. And because that, basically I live above a garage. It's finished, but it's small. It was never intended for full-time living. As a matter of fact, when I bought the property, the idea was to build something closer to the lake if it ever became a full resident space. So now that dream is kind of being fulfilled, getting married, saying this has got a couple problems. It's a little bit too small for two people, and it's also always up and down stairs. And I hate to say, but I'm getting to the point where I got to start thinking about those things. So thus, a new building was designed by myself, and the figure 6 on your handouts there is really representative of the trees that I was talking about that would be a way of building. And you can kind of see that there's kind of a natural space there that looks down upon the lake. So that's the reasons for requesting the variance of 25 feet. So I appreciate your consideration for this, and await your outcome.
Thank you.
Thank you.
This time we'll open to the public. If anyone wishes to speak, please step forward, state your name and address for the record.
My name is Jay Bush. I live near Wilmer, Minnesota. a 5.5 hour drive from here. We have the house next door to Tim's, and everything's growing up. Nobody can see anything of each other's lots anymore. We know very well that having a lake house is really a treasure, and very nice for us. Tim's been a wonderful neighbor, and my wife and I, have no objections. I don't think any of the other people had any objections either on either side. So I'm just here to support them in their effort to build a small house so they can have a little bit more room. So thank you for your consideration.
Thank you. Anyone else from the public wish to speak? Hearing none, we'll close it to the public and discuss as board. Brett?
Yeah, I understand, the zone is what it is and the laws are what they are, and they had to be drawn at a certain point in time. We seem to have a case, because as I look at figure 5, we can see the homes and the property lines that are captured within that, and evident that most of those lots have something relatively close to the property line, and that, the other side of his property line is an R1 zone. We wouldn't be having this conversation. The other thing we run into when we apply certain things like this is, lakeshore residential goes back 300 feet from the lake. If you have property on the other side of that, it's called forestry agricultural, although it can't meet any of the requirements because it's too small. It's not 5 acres, it's not those other things, but they still would say, okay, now you're gonna move your building to the 25-foot line from the property. And that's when people come to us to look to say, can we make this a little more sane for what we're going through? And here I see, despite the, the good intentions of the law, we're basically not allowing property owners to use their property like they'd like to, but for the classification that was done 40 years ago. So I looking at staff considerations and some of the practical difficulties, I find more that our legal construct is got me questioning that we would not approve this, given the reasonableness of the request.
Thank you, Brett.
Yeah, I think a similar point. I mean, what I'm seeing is that these standards are really meant for a much larger lot. And to learn that standard practice has become to take that into consideration. I'm comfortable with that in mind, and given the features of the site, the natural features on the site, to say it's quite reasonable to build in that location.
Jeff?
I'd agree with both what Brad all said, and to me, it seems like the zoning's wrong. The land use classification doesn't really reflect what has happened here, and it makes sense that a variance follows here.
I do have one point of clarification, that typically that's a resident or an owner initiated process to rezone, correct?
It is, it does not have to be. A rezone is actually a legislative action. Property owners can do that, and it provides strength if say, property owners can get the other property owners together and come in mass. But it is a possibility where we could look at an area and have some discussion about it, and it's adjusting the ordinance, actually. It's a rezone is a legislative action.
Yeah, I mean, it seems to me in the interest of the county to consider that, to reflect the actual usage of this development in the future. But I think today, I feel comfortable supporting this variance based on all the things we've just said and the findings of fact.
And on that, do we concur with staff's findings of fact? I think it'll.
I didn't find anything that I disagreed with in going through the findings of fact, so I would say yes, we do concur with their findings of fact.
Yeah, likewise, yes.
With that, I'd look for a motion.
Just take a quick look at their staff recommendations for consideration.
Was that a motion?
No, I'm looking
That
at,
wasn't even finding the
I'm
right
looking at
page.
staff's recommendations for if approved.
Okay, I was
I
gonna
wanted
say
to double
second,
check
but then
that.
I wasn't sure it was a motion, Brad, so,
Oh,
okay.
Thank you, yeah.
I'll make a motion to approve
Okay.
with the conditions as written by staff.
Do we have a second?
Second.
Any more discussion? All in favor?
Aye.
Aye.
Opposed? Hearing none? Your application's approved.
Mr. Chair, I'll make a motion to adjourn.
Second.
All in favor?
Aye.
All right. Thank you, everyone.
Okay, thanks, guys.
Okay.
You betcha.